large percentage of calls I get from folks in the field are questions related to the open meeting law. And so how I've approached this session is I'm going to go through sort of what you need to know in terms of what the law says. And then we're going to do an activity, a game, competitive game, that's going to present a series of hypothetical situations that I've either heard about directly or have encountered over the last year, and use that as a way to sort of apply the law. I'm happy to take questions during particularly the first part of the presentation, but what I'm not going to do in the workshop is respond to your own hypothetical situations, because we could very quickly get caught up in something that is really best discussed over the phone or via email. And there's so many different areas that are impacted by the open meeting law. I want to make sure we're able to cover a real broad set of those issues. So I want to take questions about understanding about what does this mean or what does this point say. But if you have particular issues that you're dealing with that you have questions about, I want to invite you to contact me personally, and I'm happy to talk through that with you. Does that seem like a good approach? Okay. So everyone's at a table. All right, so open meeting law and you. I'm going to start with just a review of the public policy statement with Vermont's open meeting law, and it's in Title I, Section 311. And it's basically that commissions, boards, and councils and agencies in the state exist to aid in the conduct of the people's business and are accountable to them. So that's the purpose of the open meeting law. And I think it's just important to remember that school boards exist to help conduct the people's business, and as such should be open and transparent as possible. So I'm going to start with a few definitions. In statute, a public body is any board or any committee of any of the foregoing boards. That's a big one that comes up. People are surprised to learn that their committees of their boards are subject to the requirements of the open meeting law. What's a meeting? It's a gathering of a quorum of the members of the public body for the purpose of discussing the business or for the purpose of taking action. When you look at the definition of a public body, and it includes a committee, one thing that comes up a lot for folks is, well, there's not a quorum of the board on the committee, so it's not a public body subject to open meeting laws. But in fact, if a board has set up a committee to help it do its work, then all you need is a quorum of that committee, not a quorum of the board on the committee, to trigger the open meeting law requirements. So I want to make that point very clear.
Just say that one more time. Yes.
Yep. So if you have a board established committee and you say, there's 5 members on that committee, but there are only 2 actual board members on the committee, another member there's a community member, there's a staff member, that committee itself is the new public body, and a quorum of that committee it constitutes a meeting. So you don't need a quorum of the school board on the committee to trigger the requirements of the open meeting law. You just need a committee that has been established by the board that has a certain number of people on it. And when a quorum of those people get together to talk about the business of that committee, they're subject to the requirements of the open meeting law.
How many, what is the percentage of how many people constitute a quorum?
Constitute a quorum? It's a majority of the. So what you should not have are sort of loose committees where, sort of anyone who shows up can be on the committee. If the board is establishing a committee to help get its work done, you should describe who needs to be on the committee. so that you have an idea of, you know, how many members do we have and what's going to constitute a quorum of that committee. Okay? Sure, Amy.
If a board member needs to be appointed to a committee, but it's not a board committee, then does that still apply?
No.
Okay.
Now, I don't want to clarify or question you on this, but I think the VSBA needs to clarify this with the Secretary of State's office just to make sure. I had a fairly lengthy email exchange with
I've seen it,
Mr.
yep.
Condos. Okay, and the end result was, because I got down to some very specific setup on that, for it to be a public body, according to what Mr. Condos wrote in his last email, it has to be at least 3 individuals. So if you just have 2 members on a committee, that is not a public body.
Right.
Okay.
Public body is, I think it's Title I, 172, a body of 3 or more becomes something that can actually take action on behalf of somebody. So if you assign 2 board members to go work on a project and they meet, that would not be construed a meeting of a public body. Thank you for that. I had a feeling you would bring that up. Thank you.
So committees can be formed of committees developed from a board. They can be comprised of staff members, public members, and board members. It doesn't have to be just solely
Board members. Yeah.
Okay.
Yeah. As long as it's a committee that's been established by the board to help them conduct business. One thing I would just want to add to your comment, Ron, is Secretary Condos, I believe, went on to say that getting around the requirements of the open, you know, simply forming committees of 2 to sort of get around the requirements of the open meeting law is not an approach that he would recommend. So just to keep that in mind. Secretary Condos is definitely paying close attention to public bodies following the requirements of the open meeting law. So
when you have like an interview committee where you have 2 or more board members that are participating with that, probably was established by a superintendent instead of by the board. Is that falling under this provision or not?
I think it really depends on who's established the committee. So if it's a superintendent hiring committee, then that's obviously a committee put together by the board and not the superintendent. But if it's for a staff position that superintendent has ultimate sort of authority over whether to recommend hiring that person or not, and the superintendent wants to have some board members involved, then I don't think that would be subject to the. And I would also say that hiring committees have a fair amount of latitude with regard to ability to enter executive session and that sort of thing. But you would still need to warn those meetings and fulfill some other requirements of the open meeting law. So I'm going to keep us moving because we are going to engage with some of these questions. Again, I don't want to give too many of the answers away ahead of time. And the big takeaway here is that any meeting of a public body is open at all times. And the key characteristics of an open meeting are that they are, the public has notice of the meeting and a reasonable opportunity to be heard. And so here are some additional legal citations around notice, so that is beyond just posting a warning of the meeting. Agendas have to be made available upon specific request so that interested members of the public can be reasonably informed of what you're going to be discussing. Both Title 16 and Title I require the public to be given a reasonable opportunity to be heard on any matter considered by the public body. But the law does allow for reasonable rules on public comment established by the chair. Any questions on those pieces? Yeah.
Changes in agenda that happen quickly so that you don't have time to update the agenda item, is that okay? You know, the printed warning?
Yeah, Yeah, I mean, you don't need to post the agenda as the warning for the meeting. So I would say if somebody has made a specific request to view the agenda and that changes prior to the meeting, you should just let that person know that the agenda's been changed, or, you know, post it. If your practice is to post it on the website or whatever, you know, post it. But there's no requirement that you post an agenda 24 hours in advance of the meeting. Okay. So there are some specific notice requirements. Regular meetings of the board do not need to be warned, but they do need to be designated in some sort of a bylaw or policy, someplace where it's sort of common knowledge. The board meets every Wednesday, every second Wednesday of the month. And you do have to respond to specific requests for information about regular meetings. Special meetings need a 24-hour notice. Has to be posted in at least 3 public places, one being the municipal clerk's office, and then 2 other public places in your community. And notice has to be given to each member of the board. Special meetings can be called for any reason, but you can really only discuss the topic that was the reason for calling the special meeting. So it's not an opportunity to say, well, we're meeting anyway, we may as well. This came up in terms of the agenda question. If you call a special meeting and it's for the purpose of, you know, discussing the budget or discussing a hiring decision or whatever, and at the last minute something else comes up that you'd like to discuss, if it wasn't in the initial warning for the special meeting, I wouldn't discuss it at that meeting.
You have a policy that talks about board operations and it includes the posting of warnings and agendas on the school website. Would that constitute as one of the 3 places?
The website?
Yeah.
I've gotten into some, I think they're talking about physical locations in the community.
Doesn't preclude us from doing that.
Oh, not at all. Not at all. It's a nice added benefit, and I think it's an expectation that people have it. And I just want to say that your policies can require more than this, and a lot often do. And so you should follow your policies, but you should be aware of what the law requires. Boards can go beyond what the law requires. And then emergency meetings, public notice given as soon as possible. But it's only allowed to respond to an unforeseen occurrence or condition requiring immediate attention. So they should be very rare, but they can happen, you know, in an hour if need be. Okay? So executive session. You cannot enter executive session without first meeting in open session. And then you have to vote to close open session with a motion that specifies the reason for entering executive session. How many people, either on your board or the boards that you work with, say things like, I want to go to executive session for the purpose of discussing personnel issues? Pretty common. Legal issues. Negotiations. So I've been giving, I think the law requires more than that, because personnel covers a pretty broad range of issues. And the purpose of executive session is really to discuss a very limited scope of issues. And boards need to be really clear about the topic they're going in to discuss, so that they don't stray from that topic and discuss multiple things that really don't need to be discussed or should not be discussed in executive session. So I think the more specific your motion, the clearer everybody is about why we're going into executive session, And so also that the public's a little bit more clear about why you're going into executive session. So do I mean that you need to say, for example, if you're going to discuss a teacher discipline issue, do you say the teacher's name? No, I don't think that that's necessary. But I do think there's a list of reasons to enter, which I'm going to go through in just a second, that are described in statute, and I think a good approach would be to basically cite the statutory language. So it's not personnel, it's the employment of, the hiring of a new position, or the, I'll talk us through it when we get to the actual reasons. But, so pay attention to the motion that's being used to enter executive session. Boards can invite their attorney, administrative staff, and people whose information they need into executive session. That person doesn't have to stay for the whole executive session, so a board can invite somebody to join them, give some information, and then leave, and then continue to deliberate. It's really the board's call in terms of how that operates. And no decision other than the decision to secure a real estate option can be made in executive session. So ultimate action has to be taken by motion and vote in open session. And the motion there should be more, if you're going to take action, the motion should be more specific than the motion to enter into executive session. So that someone could read the minutes of the meeting or be participating in the meeting and have some idea of what action has just been taken by the board. Yes, you.
You said just for the purposes of acquiring real estate, but what if you're in contractual negotiations with the association and the board has a specific position that you've taken during that executive session?
You're not taking action. So
that's not considered an action. Yeah. That's all I need to know.
A parent shows up at the board meeting with their kid to be participating in executive session. When you move to go into executive session, I mean, what do you say? That I move to go into executive session to discuss a student issue, or to discuss a drug problem, or I mean,
with students, let's get to the reasons. So students in particular, you need to be very obviously careful about, and I would say the statutory language is academic records or suspension or discipline of students. So I would say student discipline issue. End of story. So
student issue is too general.
I think student issue is.
Because even discipline would seem to me that we're kind of infringing on some privacy rights there.
Well.
And Nicole?
Yeah.
Just to add to that.
Yeah.
I'm going to side with him. In some of our smaller schools, that can be really problematic. So we've all
students sitting there in the meeting, and they're going to go into, I mean.
But remember, the whole community is not sitting in the meeting. There's 3 people sitting in the meeting. So we would say we're going to executive student issue. I don't think the parents or other people need to know, because the issue may not necessarily be a bad thing. Mm-hmm. Maybe something that it's a real private thing to do with the student's health or whatever. Mm-hmm.
Mm-hmm. Yeah, I mean, I think that's a fair approach, and particularly with students erring on the side of caution and protecting people from having an idea about what the issues are. That's probably a good approach. So I'm not going to read through these, but I just want to point out this first there are 7 sort of categories of reasons that school boards can go into executive session to discuss. There are 2 additional ones, but boards will, I think, never run into them. Pharmaceutical rebates programs and parole board stuff. So we're going to focus on the 7 that apply to school boards. The first category is pretty broad, And it includes contracts, labor relation agreements, civil actions, or prosecutions by the state. But the thing to know about this category is that a board can only enter executive session if they make the finding that premature general public knowledge will place either the board involved or the board or the person involved in a substantial disadvantage. So there was a Supreme Court case, Vermont Supreme Court case, where a board went into executive session to discuss a grievance that was broadly known in the community, and the court found because neither party would be placed at a substantial disadvantage, there was actually no reason for them to have a discussion in executive session. So what I'm advising people is just to say in your motion, if it's something that falls into this category, you add on to the motion, because to do so otherwise would place the board at a substantial disadvantage. Or to have to discuss this in public at this time would place the board at a substantial disadvantage. But I recommend that, you know, that language be used in the motion. So the other 6 reasons are listed there. There's a difference between the appointment or employment of a public officer or employee and a disciplinary or dismissal action against a public officer or employee. I think it's okay to make that distinction in the motion. So rather than personnel issues, we're either dealing with a hiring issue or we are dealing with the disciplinary issue.
So the words hiring, disciplinary, I'm sorry.
Sure, I mean, the appointment or employment or evaluation. So we're going into executive session to evaluate the superintendent. We're going into executive session for the purposes of, discussing the hiring process for the superintendent.
What a special request from an employee? A request from is...
Sure, like a leave of absence request. Yes. I would say
but that's the wording.
To discuss a leave of absence request for an employee. Okay. I mean, you could say that, or you could say an employment issue. Okay. But I would try to stay away from personnel, contracts, legal issues, and try to get a little bit more specific based on the language in statute, the basis for entering executive session. It keeps the board clear about why they're entering into executive session, and it should provide some clear parameters around what they're actually discussing when they're in executive session. Any questions, additional questions? Yeah.
I know you said that you couldn't take action in executive session, but can you reach a consensus?
Sure. You can say, okay, so when we go out into open session, are we all in agreement that this is what we're, but you can't take binding action in executive session. You have to come out and take a vote so that it's recorded in the minutes what action the board is taking. You don't have to vote on, if you're not taking any action, you don't have to leave executive session and vote on something. If it's not something that requires a vote. You can go into executive session just to discuss something.
Nicole, there's been some back and forth this year about listing an executive session on a meeting agenda. And I know the old guidelines, the old model that VSBA always had out was that you could list executive session if needed on the agenda. And that there's been some back and forth that to do so is planning in advance for an executive session, which you can't really know until you're there in open session. Where do you come down on?
So Condos, at last year in this, Secretary Condos said that it does not recommend having sort of a standing agenda item of the executive session because, number one, if it's sort of always there, well, we can kind of think of something that we need to talk about in executive session. But if, as you're planning the agenda, you have something that you know that's going to need to be discussed, I would put that item as an agenda item. So hiring of a superintendent or student issue or something, possible executive session. that's a way to sort of, you're leaving open the possibility that you wouldn't enter executive session. It is subject to a vote of the board. It's not a foregone conclusion. So I mean, I think, I agree to the extent of having it as a standing agenda item is not a good practice because it sort of invites people to sort of come up with things that maybe we should talk about in executive session when it might not be necessary.
One point, if you look at the state board of their agendas, they don't have that on there, but at the bottom they have just a saying, from time to time, the state board may need to enter executive session to handle statutory, items. So it's a broad statement, but it still allows you to.
But it's not like, from at 8 o'clock, we're going to put an executive session on the agenda just in case we need it. Yeah, I think that's a state board's doing it.
Well, I thought through this question, so I maybe answered a snicker, but except when we're protecting student confidentiality, is there any time when we have to go into executive session? The law talks about these are the ways you can, but are we required to go into executive session for things that are not around, I would assume, protecting student confidentiality?
Well, I think that there are some occasions when you would be discussing things with employees that for either reputational issues or due process issues, you should have those discussions behind closed doors. I believe employees retain the right themselves to have those discussions in open session. But I would say if the employees are saying, I want this to be held in executive session, then that's the approach that should be taken. I'm happy to discuss specific scenarios as they come up, but any other questions, Carol?
And I don't know if this is the right place where I could ask you, but disciplinary action, dismissal action against a public officer meaning who in that sentence? A board member?
That could be a board member.
So it came up in our policies, we were making policy, I was in the policy meeting yesterday, and if a board member acts inappropriately against policy of the entire SU, how do you handle that at a board meeting, and at what board meeting if you want to confront them? Is it behind closed doors, or is that something open?
Well, I think that that's a discussion you should have with your superintendent. I mean, I think to the extent that people can be sort of called out in an open meeting, that's, this is what our policy says and this is how we should be. If it's a pattern of behavior where a board member is really sort of, either you've signed a code of ethics or, and the board has some serious concerns about the conduct of a particular board member, I think you could have that discussion. The law would allow you to have that discussion behind closed doors, but I think that should be reserved for particularly egregious situations where possible harm to the person's reputation might result from having that. But to the extent board members can hold each other accountable in open session, I think that's a good thing.
Okay, thank you.
Who can ask for an executive session? Can it be your superintendent, or does it have to be a member of the board?
A member of the board has to make a motion to enter into executive session. So if your superintendent is recommending that we've got this issue that we need to discuss, it clearly falls into one of the categories that the superintendent wants that issue on the agenda, then it would make sense for the chair or whoever to make that motion. But at the end of the day, it's the board. The board has to make the motion and vote.
So could a board say, we'd rather not have that executive session at this time? I think the board can deny a recommendation by a superintendent at a meeting.
Sure. Last thing I want to cover before we get into our the competitive half of the session is just a little bit about minutes. So they have to cover all topics and motions that arise and give a true indication of the business of the meeting. I'm not getting into public records in this workshop, but except to say that minutes are a matter of public record. They have to be kept by the clerk, and they have to be available within 5 days for review and copy. Yes?
When you leave executive session, do you have a problem with a motion that just states that the board takes no action at this time as a conclusion to a reason going in?
I mean, if you're not taking any action, then you don't need a vote to not take any action.
Is there anything wrong with doing that, though?
I don't think there's anything wrong with it. I don't know that it's a good,
It just tells the public
that you haven't taken any
that you
action.
didn't make a
Behind closed
decision
doors.
about that issue that you went in for.
I think the way we've handled that is to say, you know, the board exited the executive session without taking any action. You know, we just added that.
In the minutes.
Yeah.
Yeah, but it wasn't a motion
Yeah.
that was made.
We're small enough board that we don't have a hired person doing our minutes, so one of our members do the minutes. And sometimes the problem getting them ready for public consumption within 5 days. Is that still
That's
bad?
a problem.
That's
Yeah.
okay.
Yeah. So you should work with your superintendent to figure out how to get some support to meet that deadline.
If they're a matter of, you know, we have them up, but they're up as a draft because they're not accepted until the next meeting, which may be 2 weeks later. So is that a problem, as long as they're ready in draft form?
Yeah, and you know, you don't have to post them within 5 days. You just have to have them available. If somebody walks into the office and says, I'd like to see the minutes from last week's board meeting, they have to be available for inspection. But you don't have to post them. There's no legal requirement to post them. I'm giving you guys the answers, but I'm just taking notes. Yeah?
Okay, if this is a question you're going to ask, you don't have to answer it now.
Okay.
But in the case of executive session, I think it's 213A3 for student records, which we alluded to earlier. If student is going into the meeting with the parent, the minutes have to reflect who all the partners were, all the players at the meeting, or can the minutes reflect student A, or how do you protect the confidentiality?
I don't think you need to say who went into executive session with you
You don't.
in the minutes.
You're not even the administration, just
The board went into executive session for the purpose of discussing this, and what happens in executive session in terms of who's invited and what,
Okay,
I don't think that needs to be.
that's right.
But that's a question of first impression, so I may have to get back to you on that. Yeah.
I think back to minutes for a second, I think the most subjective part of that is give a true indication of the business of the meeting. So we've gone back and forth on how much detail is actually required to capture the spirit of the conversation.
I'll tell you one example that made it says it pretty clearly. I don't think you have to, they don't have to, the statute actually says pretty specifically the types of information that need to be included in the minutes. But, and those are who is present, any other active participants, any motions, proposals, and resolutions that were made in the disposition of each, the results of any votes. And so I think that's sort of the bare minimum. And when you talk about the result of a vote, so an issue that came up this past year based in St. Albans, there was several free press articles on the topic, but the board went into the student who shot a deer on a work site, and there was a student discipline issue, a teacher discipline issue that the board needed to deal with, and the free press got a lot of coverage out of, and Secretary Condos, I believe sent a letter to the board or weighed in. When the board went into executive session to discuss a teacher discipline issue, came out and made a vote to adopt superintendent recommendation to, with regards to teacher discipline. So someone reading the minutes, the recorder wasn't at the meeting, he requested the minutes of the meeting. When you read it, you have no idea what happened. This was a big news story. People wanted to know, was the teacher suspended or not? So I think when you have motions like that, it's a good idea to ask, either, push back, amend that motion to make it more specific so that the motion is what's recorded in the minutes and the result of it. So the motion should indicate what type of action the board is taking. Yeah.
And I agree with you on everything. I'm going to ask the student question again.
Yeah.
If I'm in a situation where the decision is made by the board to expel Johnny, which Vermont law means 90 days within the school year when it's greater, I've never done this, maybe I'm breaking the law. I have the board make a motion, authorize the superintendent to act as per executive session and discipline the board.
I think with cases of student discipline, that's a safe approach. Or to follow the student discipline policy of the board. Are we ready to apply this knowledge that we have? Yes, Amy.
There's no minutes taken during executive session other than we're moving into executive session, we've moved out of executive session, this is the action we're taking if there is an action to be taken, and then you just...
Right. So the law says minutes of an executive session need not be taken, but if they are, they shall not be made public subject to public records law. So you could take minutes, it seems, for the purpose of keeping track of what was discussed, but they would be minutes that would be available to the public along with the minutes.